And the Supreme Court is to resume hearing on the Waqf Amendment Act case tomorrow. There are 73 petitions in the Supreme Court challenging the Waqf Amendment Act. The Supreme Court is likely to pass an interim order. That is expected. There were some who sought a stay on the Waqf Amendment Act. Will that come tomorrow? That remains to be seen. The Supreme Court is to pass an interim order on multiple issues, and especially three. Issue number one: should and can Waqf properties be denotified? Issue number two: the role of collector or the district magistrate or the commissioner, is that restricted? Is he a fact-finding body, or will he give a decision? And can and should non-Muslims be part of the Waqf board? I want to quickly cut across to India Today's legal editor Nalini Sharma, joining us with the latest on this big story. Nalini, 73 petitions in court, lot of arguments made. Take us through some of the prominent points and counterpoints that were made and observations of the Supreme Court, Nalini.
Well, Gaurav, the viewers should know that the Supreme Court, in fact, was very keen on passing the order today itself. They had identified three main concerns on which several questions were even raised to the central government through Solicitor General Tushar Mehta, who was representing the centre before the Supreme Court three-judge bench. What were these three main concerns that the Supreme Court had regarding the Act? Number one was regarding denotification of these Waqf bodies. Now, according to these acts, that any body that is not officially registered as a Waqf property is going to be denotified once the Act is brought into force. The question that the court had is that any property that has been recognized as a Waqf property by the court, whether it be Waqf by user or Waqf by deed, can that not be denotified, at least for now, till the time the court is hearing the matter? That was the first question that they asked the central government. The second question they asked the central government was regarding the role of the collector. Now, what is happening according to the Act is that the collector is given the duty of holding an inquiry as to whether a particular property is a Waqf property or a government property. Now, during the time that this inquiry is going on, it is said in the Act that this property cannot be considered to be a Waqf property in that interim period. So the court has questioned whether or not this proviso, where this in the interim period the property is not considered to be Waqf property, should this be allowed to continue, or should they stay this particular provision? The third and the most important that the Supreme Court has asked is regarding the inclusion of non-Muslim members into the Waqf boards and the Central Waqf Council. The Supreme Court has said that they should be limited to two, and although the Solicitor General has given his statement on record that it will be limited to two, the court has also said that this should only be ex-officio members and not any of the other members. So on these three aspects, the Solicitor General has sought some time to place his arguments before the Supreme Court tomorrow. He's requested them to not pass the interim order today. That request has been accepted. At 2 p.m. tomorrow, the government will get some time to place their arguments on these aspects, and then the Supreme Court will decide whether there'll be a stay on some aspects of the Act or not, and whether the Act will be allowed to be enforced in its entirety or not.
So there were several pertinent points that were raised, let's take this point by point. There was one issue about the court made an observation about a 15th century or a 16th century or a 17th century Waqf property or a place of worship which may not have documents. That remains Waqf property, that remains a place of worship. Did the court make an observation on that? And what happens to a property that has since been declared a protected monument?
So, Gaurav, the first part of the question that you raised will be tackled by the Supreme Court in the first point that I stated as to whether or not such properties should be denotified. Now, the concern of the petitioners was that how Waqf by user actually works is that there are no official deeds in place or documents in place that recognize that property as a Waqf property. It's considered to be a Waqf property by virtue of the fact that it's been used for Waqf purposes for several years. So should such properties be denotified or not is the main question that the Supreme Court was considering, because that was one of the biggest points of objection that even the petitioners had raised, saying that there are so many old properties that have been Waqf properties by virtue of the fact that they've been used as Waqf properties, and it's not possible to find the documents of all these monuments and masjids that have been functioning from the 14th or the 15th or the 16th century. The Chief Justice agreed with him, and the Chief Justice did say that it's not possible to find these documents. So in that case, whether or not the court can intervene and the court can step in and take matters into their own hands and assure that there is some sort of a balanced interim order that's passed. So neither of the two sides, neither of the two parties feel like it's tilted in their favor, and at the same time, the court is also handling the matter so that the hearing can go on and the matter can be decided in its entirety as soon as possible.
Keep tracking that story, Nalini. I will come back to you for more.